Okay, thank you, Patty, very much. And our second panelist to answer this question is Scott Freehafer. Scott?
Thank you, Chris. In addition to what Patty said, one of the points I'd like to make is that you have to consider what the purpose of the information being sought is for. Is it pertinent to the job or to the organization, or are you just curious about the person? One of the things in my background, if you did a background check on me, you'd find that I've taught in many prisons, did some correctional education work for a university in Ohio. And while I was working with the students then in that setting, there were a lot of interesting things that I could have asked. But one of the questions that they told me about is they actively do lie. Now, in terms of the ethical obligation, you have an obligation for all people to do the background checks in a fair and consistent manner. But in terms of what information you're seeking, you have to understand the purpose for which you are pursuing that information. And don't just snoop. Don't be curious. Have a business-related reason for asking the questions that you do. Back to you.
Thank you, Scott. All right, and that moves us to our question 3. And a quick information for our audience, sometimes there's a little lag between the time in which I pass the slides and the time that you actually see it. So this is normal, just be a little patient. So right now our next question is related to applicant rights. What are the applicant's rights regarding background checks? And the first person who will answer this question is, again, Patty Wise.
Thanks, Chris. Really, the rights that applicants have come from a plethora of employment laws, and just some of those. I guess what we'd probably think of first would be Title VII, but then followed by the Americans with Disabilities Act and that act as amended, the Age Discrimination in Employment Act, so really covering all the protected characteristics, and then newer on the same GINA, the Genetic Information Non-Discrimination Act. All of those laws tailored to protect applicants. And you have to remember, it used to be in the United States, we didn't have protection for applicants, and employers could ask anything. Nothing was off limits. And prior to 1964, when Title VII was enacted, employers could ask who you voted for in the last election. They could ask about your personal habits at home, whether you gambled. Really just nothing was off limits. And so I think sometimes when employers feel very constrained in what they can ask about, we have to remember that these are corrections for a time when applicants had virtually no protection. Most of these laws, again, relate to what I referred to before, those protected characteristics and protected activities. So not asking questions on the basis of gender, religion, or questions designed to collect that kind of information, age, things like that. I just was reading about a case in the UK where a law firm, and you would like to hope that they know a little better, but a law firm was interviewing a woman candidate who was a new mother, and apparently there's an email sent from one partner to another which says, and I'm quoting here, "This lady has recently had a child. Are there any guidelines on how we can ask questions properly designed to identify her commitment, hours she is prepared to do, how she will balance work and a child?" And I guess the guidelines would be that those questions are clearly off limits, and those aren't appropriate questions at all. It also really ties into the idea of gender stereotyping, asking questions of one gender that you wouldn't ask to another gender, so entirely inappropriate. And again, that will be something to watch this UK law firm and see how that turns out for them, but I would guess not very well. Because again, all of this kind of information, protected characteristics and protected activities, is completely off limits. So the applicants have very broad rights in terms of protecting themselves on the basis of those kinds of questions. Another thing that comes up is are questions about applicants outside the workplace, so work activities that happen outside of work hours or outside of the work location. And you, again, have to be very careful here to be aware of the law of your particular jurisdiction, your state or country. Some take the approach that work activities or activities outside the workplace are entirely within the privacy of the applicant, and they're off limits to employers. Other states or jurisdictions take an entirely different approach and say that anything is fair game for employers. And again, I think this will tie in when we talk later about social media and Web 2.0 facilities. But you have to know, again, what your jurisdiction prohibits and what's allowed. In the United States, we see a vast difference among the states that are tobacco-producing states, which tend to more strongly protect applicants' rights in terms of out-of-the-workplace activities, and states that are not tobacco-producing states, which is kind of an interesting distinction, but something to be aware of in every jurisdiction. Chris, back